SJC-11748, adoption of Quan.
Good morning, Ms. Driscoll.
Good morning, Your Honors. Thank you very much. Roberta Driscoll today for father, who asked this court to affirm the decision of the trial court granting him relief from judgment and vacating the stipulation for the entry of decrees terminating his parental rights. It is our position today, Your Honors, that father was entitled to relief from judgment pursuant to Rule 60B1 because his stipulation to the entry of decrees terminating his parental rights was not knowingly and voluntarily given. Rather, it was the product of a fundamental mistake of law.
How do we know that?
How do we know that it was the product of a fundamental mistake of law?
How do we know that?
Because I think the trial judge very candidly said, I was wrong. I thought that,
We have no colloquy in front of us. There obviously was a colloquy at the time that this stipulation was signed.
presumably there was, but there is no transcript, there's no record reference to the
No
fact that...
possibility of a transcript? I mean, what did the judge base his finding on? Just because he misunderstood, so everyone else must have misunderstood?
Well, I think he based his finding on the fact, yes, quite honestly, that he was wrong and that his...
He was wrong when? When he accepted the stipulation?
The stipulations were executed on February 25th of 2013, and at that time in this particular court, it was the common practice to allow parents to stipulate to unfitness and to the entry of decrees and to actually enter the decree, and that's really the problem here, right?
But in connection with that stipulation, there was a colloquy, was there not?
Presumably there was. There is no transcript available of any colloquy, and there is no record reference to what was discussed at the colloquy.
When you say no transcript available, I take that to mean there isn't one yet in existence, but does that mean that it's gone?
I would leave this to my sister to answer, but my understanding is that there is no recording of any colloquy.
There never was?
I can't speak to what might have existed at some point. I know that at the time that we were putting the record together, there was no recording available of any colloquy. So we don't know what was discussed.
What's a colloquy? Do we know that?
I don't know that for
The
a fact,
docket
Your Honor.
reference.
I'm sorry?
There are docket references that there was a colloquy.
I don't know what was discussed at the colloquy, Your Honor. I don't know whether the specifics of father and mother's right to seek appellate review of any adverse decision was something that was discussed at that time. Presumably, I would point out, though, presumably, the trial judge, in the process of accepting the stipulations executed by the parents, read the stipulations. They were not instructive to him as to the lack of availability of appellate rights for an adverse decision.
Help me on this. The stipulation reads, the child's birth father has retained his rights to a so-called best interest hearing regarding placement, guardianship, and/or adoption.
Correct.
Under the law, after termination of parental rights, does a father have any rights to a so-called best interest hearing?
Well, the law at the time that the stipulation was executed in February of 2013, what this trial judge was abundantly aware of was that two of his cases, circumstances virtually identical to this one, where an aggrieved parent, similar to father, had stipulated to termination of parental rights, had the decree had entered, parent had been allowed to participate in the best interest hearing, and then that aggrieved parent had sought and was granted appeal to the appeals court on the issue of best interest. And this is the adoption of Uriah and the adoption of Kiara. And those are two unpublished opinions, but neither opinion makes any reference to the fact that these parents were not entitled to appeal, but were somehow allowed to appeal. The fact of the matter is, they sought and were granted appellate review by the appeals court on the issue of the best interests of the child. That was the standard.
Best interest of the child vis-à-vis placement only.
I'm sorry, you're absolutely right, Your Honor. The best interest hearing for the child. This was the state of what was understood by the trial judge at the time that these stipulations were executed. It was not until nearly 8 months later that adoption of Malik, which is a published appellate court opinion, came out and specifically said a parent who negotiates, like this one did, parent who negotiates for the right to participate in a best interest hearing has no right of appeal. The very frustrating part about this case, Your Honors, though, is a footnote in Malik says, of course, by agreement, they could have agreed to post-date the entry of the decrees until after the best interest hearing, thereby preserving the parent's right to appeal. In this particular case, the appeals court recognized that and said, well, other parents similarly situated could make a similar agreement, but that's not available to this father because we're vacating the trial court's decision and reinstating the termination of parental rights decree.
And should we understand adoption of Malik to mean where you do not postpone the termination date until after the best interest hearing, that if a judge, that the father, upon termination, has no right even to a hearing?
I think that's what Malik says, Your Honor.
Not merely appellate rights. The father has no rights with regard to that hearing, period.
The father has, you're right, there's no constitutional right to participate in the best interest hearing. I think Malik leaves it to the discretion of the trial judge to allow or not the parent to participate in the best interest hearing. But with respect to the right to seek appeal from any adverse determination, no, I think Malik makes clear for the first time that a parent who negotiates and executes a stipulation with the expectation of having that right would not have that right. And I think that was absolutely not clear at the time that the father and the mother executed these stipulations. And I think it was equally unclear to the judge. I mean, this is what he says in his memorandum of decision. He says, I was mistaken, and my mistake colored the decision-making in this case.
He doesn't say, however, that he conveyed that impression in however he conducted the colloquy.
He doesn't come right out and say that, Judge, but I think it's
Doesn't say it.
implied by saying that his misunderstanding of the law impacted.
Would it be necessary, if this were remanded, for example, to ask the judge whether that is what he conveyed and that's where the assurances came from? It's unclear whether the assurances came from counsel. I don't think we have counsel's affidavit that they gave those assurances, do we?
We don't have any affidavits from counsel, and I think that's a very good point, Your Honor. I think there are a number of questions of fact that might have assisted in resolving this case. One would be, certainly in the context of a year's worth of court hearings in this case, was there ever any reference to a parent's right to appeal? But I think beyond that, it would be instructive to hear from the parents themselves as to what their understanding was. The affidavits that they submitted, I think, made clear, certainly in mother's case, maybe less clear in father's case, that this was their understanding that they would have the right to appeal an adverse decision from the best interest hearing. And what I think the appeals court said was essentially, we don't believe you. And I think that's a hard decision to come to when there is no inquiry on the part of the court to either parent as to what they were told, what they understood, what their beliefs were. So I think there are facts that could assist in a resolution here.
I'm afraid your time is up. Thank you.
Thank you, Your Honors.
Good morning, and may it please the court, Ann O'Connor for the appellee mother. To Justice Botsford's question, according to the clerk at the Worcester Juvenile Court, the recording of the colloquy either has been misplaced or there was no recording made. They can't tell us why. There's no CD from that date. But respectfully to Justice
Usually they
Duffy,
are, though, right? I understand in this case, but the usual practice is that these things are recorded.
yes, absolutely. But here we have the judge who conducted the colloquy saying that the stipulation was unknowing and involuntary. And he points out that not only did he believe the parents had the right to appeal, but the department believed that the parents had the right to appeal. And on the very first day of the transcript, the volume 1 of the transcript actually consists of 2 days, the first being in December, and the judge puts it to counsel for DCF. Did these parents stipulate on the belief that they had a right to a best interest hearing with the right to appeal? And DCF counsel says yes. Subsequently, she sort of tap dances around the issue, and on appeal, both below and here, counsel for the department never outright says, we never believed that. They just sort of leave it lie. But the trial judge was quite clear that based upon 10 years of practice in hundreds of cases, the department's counsel and counsel for the parents, as well as in this case the parents themselves, believed that they would have the right to appeal from an adverse determination in a best interest hearing. The procedure that was used here obviously was flawed, and if it gives the panel comfort, certainly in most cases, in most juvenile courts in the Commonwealth, it's not done this way. Parents may at trial concede unfitness and then litigate the plan, but no decree enters until after that process is finalized, which points out the other problem with the decree that entered here, and why the judge, even if this court were to deem him to have abused his discretion in finding that the colloquy was unknowing and or the stipulation was unknowing and involuntary, he had to vacate the decree because there can be no decree until the judge chooses a plan. And that's clear in the statute. In determining whether the best interest of the child is served by terminating rights, the court must consider both parental unfitness and a plan. The plan proposed by DCF is what the statute says, and the plan proposed by DCF or the parent is what this court said in Hugo. The appeals court said decades earlier, and this court routinely has passed upon. There must be a plan that is deemed by the trial court to be in the best interest of the child.
I'm misunderstanding here. Let's assume that this issue with respect to appellate rights was not before us. What you're saying is the termination of parental rights was not effective at all until there was a best interest hearing? Not effective.
Well, it was certainly voidable, and the trial court voided it by vacating it. The statute requires, Your Honor, it's a two-part analysis, parental fitness and plan.
I understand that, but I'm trying to ask.
Sure.
You're saying that the termination was not effective. No termination is effective until there's a best interest hearing?
Correct, until a plan is approved for a child. Is the appeals court put it in DORA entry of, approval of a plan for the child.
This termination isn't effective anyway.
Correct.
So it's
It-
Malik.
it's vacated.
Never was effective because there's never been a best interest hearing.
Which
So-
is why the judge properly vacated it under 60B4. It was void.
But how does that square with Malik?
Yeah.
Right. Malik changed the law, essentially. Malik
But
just,
according to you, this is by statute, so, I mean, is Malik just dead wrong in your view?
yes, Your Honor, I would respectfully say Malik is dead wrong. It doesn't comport with the statute, nor does it comport with the prior decision, I think in 91, adoption of John, where the Justice Duffley, writing for the court, said even where a termination decree is entered on a parental consent, it still must comply with all the statutory requirements, including determination that a plan is in the best interest of the child.
So help me here to understand. You're saying that termination can occur only when there's a finding that the parents are not fit and that the judge has determined where the child should go.
Not necessarily where. There can be what's called a recruitment plan, which is a plan in which usually the department, whoever initiates the petition, says, we don't have an actual home now, but we'll tell you what kind of home we're
But it
seeking.
must be at least a plan of action.
Correct, and it must have content enough. I believe Justice Lang wrote in adoption of Stewart for the appeals court, it must have content enough to allow the judge meaningfully to assess what the department plans to do for the child.
So once there is a finding of unfitness and a plan of action, then the termination order may go into effect.
Yes, Your Honor.
And under adoption of Malik, once that goes into effect, then the parent loses the right to appeal the placement determination.
But
Well, if the parent litigated, we have many cases, Your Honor, where the reviewing court will say, at trial, the parents waived the issue of unfitness, but litigated the plan, so we'll review their appeal from the plan decision. But
but
if,
in Malik, didn't judgment enter when there hadn't been a best interest hearing yet?
correct, Your Honor. Correct, Your Honor. And that's what happened here, and that's the flaw, apart from everything else, with the decree. It entered without comporting with all the statutory prerequisites to its entry. In this case, the determination of which plan meets the child's best interest.
All right, thank you.
Thank you.
May it please the court, Brian Pariser for the Department of Children and Families. To go back to Chief Justice Gantz's last question, the prerequisite for a valid termination decree is the finding of unfitness and approval of a plan of action, and that is exactly what happened in this case. To go back procedurally...
That's happened before there was a best interest hearing. Hasn't been a best interest hearing.
Yes, and I'll take a moment to explain how that's the case. In this case, the parents, at the day of the trial, stipulated their unfitness, and that was based on evidence, documentary evidence taken by the court. So there was really no objection and no issue about parental unfitness. The parents negotiated a settlement by which they reserved a right to be heard at a best interest hearing, and they also negotiated other benefits after the entry of a termination decree, which are overlooked by my sisters, namely post-adoption contact. There is an agreement in the record that was signed by the parents that was accepted by the court, which allows for post-termination and post-adoption contact. That would not have happened if a decree entered on its own. The parents negotiated for that benefit that they would not have had but for the negotiation. Now, that said, the plan that was approved was a plan of recruitment. What the parties agreed to in the document was termination of parental rights. A decree will enter forthwith, that's the language of the agreement, subject to a best interest hearing. The parents also wrote in by hand on their agreements that they were presenting certain plans. In their cases, various relatives of the mother and father, okay? The department had a plan of adoption by the current proposed pre-adoptive parents, the foster parents. That was going to be the subject of the best hearing. But what was accepted by the court was that regardless of the outcome of that best interest hearing, that any one of those three plans would have been sufficient. In essence, the agreements that are signed by the parents refer to recruitment plans. They refer to the adoptive parent. And it says any one of these three people that's approved will be referred to in these agreements as the adoptive parent. Furthermore, a few months after, I believe it's 3 or 4 months after, 29B, that's the permanency hearing, came before the court, and the court approved a permanent plan of adoption, all before the best interest hearing. The court
What would the best interest hearing have consisted of then?
The best interest hearing would have consisted of taking evidence and determining which of these three specific placements that were on the table served the child's best interest. So, and that is what the parents negotiated for the right to be heard at. Clearly, they wanted to present evidence. They wanted to present that proposed placement so the court could decide if the grandmother was better than the foster parents or vice versa.
Are you saying that as a result of the stipulation, the judge would not have been able to say that all three of these were inadequate?
Well, I think the judge always reserves the right after hearing evidence to reject a plan. I'm not saying the judge would be bound by that. What I am saying is that the court approved a plan of adoption, understanding it was going to hear and take evidence on three plans. If they were all insufficient, I don't think there's anything that would bind the judge to.
Upon determination, if you move to a best interest hearing to determine where the placement should be, could the judge say to the father, I'm sorry, your parental rights have been terminated. You have no right to be heard at this best interest hearing?
Well, I would submit under the normal conditions, yes. But in this situation...
Yes, he has no right to be heard?
Yes, he would have the right to bar the parents under usual conditions after the entry of a TPR. But in this situation, the parents, part of their negotiation of the waiver of their right to a trial and the waiver of their right to appeal the entry of the 210 decree, that's also expressly in that agreement they signed, part of what they negotiated for was the right to be heard at this best interest hearing.
So you do have a right to be heard where you otherwise would not if you negotiated it before the termination?
Just as they would for post-adoption or post-termination contact. You wouldn't have that right either after the entry of a decree.
But you would have no, if you were to fail to prevail in getting the placement you wanted, then you would have no right to appeal that determination.
Under the facts of this case?
Under adoption of Malik.
Yes, that's correct. But there's still a value in being heard at the trial court level and presenting evidence, even if you, and that is something you would not normally have after the entry of a decree.
Well, wait a second. If you had a trial and no stipulation, are you saying that the evidence as to what the department proposed to do by way of placement of the children would not be part of the trial at which the parents would be able to participate in?
I'm sorry, I didn't.
If you were at the trial, and the judge doesn't normally make a finding as to current parental unfitness and a termination at trial, I mean, that's done afterwards in the voluminous findings that the judge makes.
Right.
Evidence would be taken also at the same trial as to the plan, would it not?
Yes.
And so the parents would participate in that, or would they not? In
If
that
there was no
aspect of the trial?
stipulation, yes.
If absent
Yes,
a
they would.
stipulation, they would.
Of course.
So all they're doing is preserving in a stipulation what they would have had the right to do at a trial in any event.
Only that piece of it. I want to be clear.
Well, that's because they've stipulated as to the unfitness component.
But we, if I may, we don't know what went through the parents' minds. The parents assumedly reviewed the evidence with their counsel. They were represented by counsel. The parents looked at that evidence and presumably determined there was not a likelihood of success at trial. That is the reason,
You mean
in most
on
cases,
the
for a
unfitness-
stipulation.
On the unfitness question.
On anything. They stipulate to the entry of a termination decree. They fully recognized that a decree would enter. And perhaps they felt that they were gaining something by not having a trial. They were clearly negotiating for some ongoing contact after the entry of a termination decree and even after the entry of an adoption decree. That's in the decree. And they also figured, at least we can be heard on where the child lives. So they did reserve something.
Well, let me just continue with that. If there had been a trial and those components of, the evidence relating to unfitness was part of the trial, and then there would be a component of the trial also having to do with the placement plan for the children.
Yes.
And there was a decree that entered at the end of all of that in which parents' rights were terminated and the plan for the children was not the one that the parents wanted.
Yes.
Would they not be able to appeal that in its totality?
Yes, they would.
They would.
They would not necessarily have had a right to visitation, however, after that
I understand
trial.
that, but the
Now
question...
I'm accused. This best interest proceeding would have been part of the termination proceeding? That's not right.
The case law requires that the elements that the trial court is considering are cognate and connected, and that is the best interest and the parental unfitness piece. So in the normal course, if there are no stipulations, a trial would hear evidence regarding both parental unfitness and the best interest.
But the best interest in terms of who gets to adopt?
Not necessarily, and that's what I want to make clear. The language of the case law about being cognate and connected speaks of the best interest to enter a termination decree. That termination of parental rights is in the best interest. A part of that is what the future plan for the child is.
Adoption versus something else, but not who's going to adopt.
Why there is substantial case law cited in the department's brief. This court has approved a adoption by recruitment where there is no identified plan.
So let's assume for a minute you had a termination trial. Parental rights were terminated. Would the department at some point have to come back and ask for a hearing with respect to the specific adoption plan? Like who was going to adopt?
No, but that would be presented in the course of a 29B plan, a permanency plan. The court would still hear from the child and the department regarding that plan and have oversight over that plan. But it would not be a part of,
during the termination trial?
if the decree entered, the court still exercises ongoing jurisdiction over reviewing that plan through the 29B process.
So the plan has to come back before the court at
It
some
will ultimately, the plan comes before the court for the adoption petition as well. So multiple times it will probably come before the court in reality. It's a question of whether the parents are present at that or not. But just one more issue, and that is the question of what the parents knew when they stipulated and whether Malik changed the law or not. I understand there are issues of fairness here, and I would submit that some of those issues of fairness relate not only to the parents' expectation that they rely on, that they had a right to appeal, but also the fairness of the fact that what they negotiated for. Remember, if this decree is thrown out, what they negotiated for will also be thrown out. So there's a fairness element that's overlooked there. Obviously, the child has a tremendous stake here in what's going to happen if this matter is sent back for a new trial where the parents had long ago already admitted that they were unfit and admitted that termination was in the best interest of the child, only with a discussion about which plan.
Well, but I guess I took the judge's ruling as saying, no, we're not going to revisit unfitness. What we are going to do is have the parents participate in the best interest hearing, which hasn't happened yet. And if they don't like, where it is that I decide this child is going to be placed, let's just say with the adoptive parents, then they will have a right of appeal. But I did not think that unfitness was open by what the judge said.
He vacated the decree. I can only assume that unfitness is open. Once a decree is vacated, I assume we start from square one. The appeals court did understand that, I think, and the appeals court, in reversing the trial court, did still instruct the trial court, even with the decree in place, to hold the best interest hearing forthwith. There may not be a right of appeal from that, but the appeals court still did instruct that that hearing should take place and the parents would be presumably heard at that hearing.
You say presumably heard because they obtained it through the stipulation, or because they have a right to be heard?
I believe they obtained it through the stipulation.
But they otherwise don't have a right to be heard.
They were also promised it by the judge through his acceptance of the stipulation. I think it would be hard-pressed to withhold it from them at this point.
Well, the appeals court ruling, I think, looks as though they can't, that he was wrong. They can't do that.
The appeals court ruled that he could not, that it was error to vacate the decree. And in the normal course, I think, I don't know that the appeals court touched on the question of a remand where they were actually reversing the termination decree. I think, the appeals court reiterated the rule in Malik, and the rule in Malik would normally be that they would not have a right to be heard there. That's somewhat different than what happened in this case, where the parents...
But since they're the appeals court and we're the SJC, is there any reason why we can't say that when you reserve your right to be heard at a best interest hearing, then we will give you a right of appeal, and therefore he will have gotten what he was promised?
Yes, and I think I've made that point. I don't dispute that point.
And is it your view that that's what would be a wise thing for us to do, to essentially reverse Malik and say where you have reserved a right to be heard at a best interest hearing, that you also essentially have the right to appeal that determination?
Those are two different matters. I apologize if I misunderstood your question, Chief Justice. I think that if the parents, through the course of settlement negotiations, agree to give up certain things, like the right to a trial, like the right to an appeal, but reserve certain things, like the right to post-adoption contact or the right to be heard, those are things that normally wouldn't happen, then I think they have negotiated for an agreement that's accepted by the court.
But that does not, from what you've just said, doesn't include a right of appeal.
That's correct. That is correct. And I think Malik says that, and I think that is in keeping. And I think the appeals court in this case, just to bring it back to the record for a moment, was clear that there is nothing in the record to indicate that a right to reserve a right to appeal from the best interest hearing was reserved.
Do you agree that the practice had been that was the understanding?
I do not know what the understanding is. I can't speak, obviously, for people in the courtroom. I do agree that there had been a practice whereby, and obviously those two 128 decisions speak to that, whereby people did appeal the results of best interest hearings. And for a couple of cases, the appeals court allowed that to happen for one reason or another.
And
That doesn't
DCF
mean
didn't
those,
raise an objection to that.
and that is the point the department makes. This is like a piece of evidence. No objection was made. The department did not object to that procedure in those cases. I will concede that. There could have been numerous reasons the department didn't object. I don't think we can read into trial counsel's mind that they believed there was a right to an appeal. It could have been expedience. It could have been a matter of policy. It could have been a way of resolving cases faster. That doesn't mean that it was, a legal interpretation from the department or even the department's understanding. It was allowed to happen, and the department did not object to it happening. And then the appeals court handed down its decision in Malik, which is not a surprise, shouldn't be a surprise to anyone given what the state of the law was. And even if it was, the one concern that I would have is that on an ongoing basis, every decision that this court hands down clarifies the law in some respect. Most decisions of the appeals court clarify the law in some respect. If this court says that it is permissible for a party to settle a case with the assistance of counsel and with tangible benefit adhering to them, and then, after the entry of a decree, can file a 60B motion based on a subsequent decision that comes down, a foreseeable decision, I would argue in this case, but any subsequent decision that comes down, there is no permanence in those decrees.
But the appeal from the best interest finding wouldn't be an appeal of the unfitness of the parents. It would be appeal of whatever the court found was in the best interest of the child.
If
That's the same issue, though.
Well, I'm less troubled if that's the finding of this court. I had understood that the decree was
It can't be
vacated.
the same issue, because it can't be the same issue.
No, but it is an issue. I mean, in other words, if let's just say.
Wait. At the best interest of the child hearing in this case, you would revisit whether or not the parents were fit and therefore could have the child back.
I'm saying the trial court ruled that the decree was vacated. If we did not have an appellate process, with the decree vacated, the department would have to start from square one.
And that's because the stipulation the judge found was not entered into as a whole on a knowing and voluntary basis. And that's why the whole thing was set apart, because it was all done as part of a stipulation that the judge had a quarrel with as to whether or not the parents knowingly and voluntarily executed the stipulation, right?
Yes, but again, I take issue with his finding, and obviously the appeals court did too. The appeals court found that that was clearly erroneous based on the record.
But we don't have a complete record.
We do have a
Well,
complete
we don't
record
have
that
the
was
stipula-
created
we
by
don't-
the trial
we don't have,
court.
We don't have any idea what was said during that colloquy as
That
to the
is-
stipulation.
You are right, we do not. That
And that's the
record was
key
not
question.
made, and nor was there any effort by any party to recreate that record from memory.
Aren't you the appellant?
I'm sorry?
Aren't you the
I
appellant?
was the appellant.
So it would fall on you.
If it would fall on me to create a record that allowed for appellate review, I believe I did that. No party objected to the record that was created in the appeals court. No party made an effort to supplement that record. I believed, and the appeals court believed, there was an adequate record for appellate review.
All right, but thank you, your time is up.
Thank you.
Good morning, Your Honors. May it please the Court, Attorney Robert McCarthy, Jr. for the appellant child. No, we don't have too much time this morning, but he would just make 3 points. One, that he wants a permanent adoptive home. Number one, he's been in a pre-adoptive home for almost 3 years.
The same one, is that right?
The same pre-adoptive home for almost 3 years. That's 2/3 of his life without having permanence. And that delay in this case is prejudicing the child, and that he agrees with the decision below in adoption of Malik. As far as General Law, Chapter 210, Section 3 is concerned, it doesn't call for bifurcating a trial. At a termination of parental rights hearing, you would have a decision made of whether a parent was unfit, whether it was in the best interest of the child to have the parent's rights terminated, and the 3, if all the previous 2 are true, whether or not where the child would be placed. So if a parent could enter into a stipulation to terminate their parental rights, And the judge doesn't have to enter an adjudication terminating parental rights until the entire proceeding takes place. That wasn't done in this case. The judge entered in an adjudication terminating parental rights, and then the best interest hearing was postponed for 10 months.
But at the best interest hearing, would the issue be whether it's in the best interest of the child to terminate the parental rights? Would that be the issue?
That would be the issue if it wasn't bifurcated like it was in this case. In this case, the judge took the stipulations and it was decided that the parental rights should be terminated.
Without considering the best interest of the child?
Well,
This is very
presumably he
confusing.
did. He did take into the child's best interest. It was written down in the finding that he made that it was in the child's best interest. And that is where the appellants are making an argument like was made in Malik, adoption of Malik, where the parents argued that the best interest determination was made before the placement decision was made. And the appeals court rejected that argument and said, you already stipulated to a termination of parental rights. You don't have the right to come back and complain about the procedure. And that's the same argument that the appellants are making in this case.
All right, thank you.